afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While you are waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Thank you for joining us for today's online talk entitled Introduction to the Strata Management Tribunal. My name is Ashvinderjeet. I'm a paralegal with Ma Wing Kwai and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce you what Ma Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today comprises of 24 lawyers and a support team of 19. Datuk Ma is today the consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small medium enterprises, family businesses and individuals. We are a full-service law firm with a corporate department, a dispute resolution department including litigation, adjudication and arbitration, a dedicated employment team and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talks series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Please visit our website at mawingkwai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation, details of which will be given at the end of this talk. Allow me to introduce our speakers for today. John is a senior associate in our dispute resolution and employment department. He was admitted to the Malaysian Bar in 2014. His areas of practice include employment law, unfair and constructive dismissal disputes, contractual and commercial disputes, debt recovery, strata management disputes, and director and shareholder disputes. Whereas Celinne is an associate in our dispute resolution, strata management, employment, and corporate litigation department. She was admitted to the Malaysian Bar in 2021. Her areas of practice include dispute resolution, general litigation, strata management disputes, employment and corporate litigation. The top points that will be discussed today are jurisdiction and powers of the tribunal, procedures and proceedings, tribunal award and compliance, and challenging a tribunal award. If you have any questions, please don't forget to post it up on Slido or in the chat. We will address them at the end of the presentation. You can access the Slido page by scanning the QR code on this slide or going to the Slido website and key in the number 793955, which is also on the slide. To be fair to the attendees today, we would appreciate if you can confine your questions to the topic discussed. I will now pass on the floor to our first speaker of the day, Celinne. Celinne, over to you.
Hi everyone, thanks Ashvinder. To all the participants today, we hope that you can kindly mute your audio so that everyone can hear. Yeah, hi, can everyone hear me? Well, the relevant legal provisions for the Strata Management Tribunal are the Strata Management Act, and I will be referring to this as A moving forward, as well as the Strata Management Tribunal Regulation E, and I will call this a regulation. The Strata Management Tribunal is established pursuant to Section 102 of the SMA to resolve strata management related to efficiency, cost effectiveness, and speed. There is a client charter by the tribunal that settle claims within 150 working days. Where are these Strata Management Tribunal located? The head office is in Putrajaya, and there is also a Lumpur office. And then for those of you who are listening from other states, there is one in Penang, a few in Johor, and there's one more in Anu. So please note where, if you are someone who is responding or a defendant responding to the statement of claim, please take note of the entitlement on the top, which tribunal it originated from, because you have to serve your defense back to that tribunal where it came from. And what are the jurisdictions and powers of the Strata Management Tribunal? Well, first of all, we're happy to note the Limitation Act does not apply to tribunal meetings. So unlike the civil court, there is no limitation for you to commence your claim at the tribunal. And second thing to note is the total amount of your claim must not exceed 250,000. So anything beyond that, you do have to go to the court. And the Strata Management Tribunal's jurisdiction is limited only to all claims specified in Part 1 of Schedule of the SMAs. And there are certain other provisions in the SMA which provides directly for the jurisdiction of the Strata Management Tribunal. So looking at Part 1 of Schedule, you can bring a claim to the tribunal if you have a dispute or complaint concerning an exercise or performance of a function, duty, or power conferred by the SMA. So usually if you have a problem with like the developer, the MC, the JMB, the management corporation, the joint management body, you can bring a complaint against them, and subject to Section 16N, Section 2 of the Housing Development Control and Licensing Act. You can also bring in a claim for a dispute of cost or repairs in respect of a defect in your parcel, your building or land. And for developers, the management corporations, the joint management bodies, you can bring in a claim for recovery or as well, or even contribution from the fund or any other debt that is declared as a debt according to the SMA. You can also claim for an order to convene a general meeting. You can also get a claim for an order to invalidate proceedings of meeting any of the provisions. Moving forward, you can also get a claim for an order to nullify a resolution where your voting rights have been denied or where due notice has not been given. So let's say you have paid for your maintenance charges, but somehow the management body doesn't allow you to vote, or they didn't give you the full voting right according to the maintenance charges you have paid in accordance to your share unit. So you can go to the tribunal for these. And you can also get a claim for an order to revoke any amendments of the bylaws having regard to all the interests of the parcel owners or proprietors. So you can also get a claim for an order to vary the rate of interest fixed by the JMB, the MC, or the sub-MC for late payment of charges. And you can also get a claim for an order to vary the amount of insurance to be provided. And you also can get a claim for an order to pursue an insurance claim. You can get a claim for compelling a developer, a JMB, MC, or sub-MC to supply information or document. And alternatively, you can also get a claim for an order to give consent to affect any alteration to any of your common property. And you also can get a claim for an order to affirm, vary, or revoke commissioner's decision. So the commissioner referred to here is the commissioner of building. And as provided for in Section 77 of the SMA, it also includes claims for orders to enforce the performance of or restrain the breach of any of the bylaws in the building. And it also includes claims for recovery of damages for any loss or injury to any person or property arising out of the breach of any bylaw. What it does not include is the claims in which the title to any land or any estate or any interest of the land franchise is in question. And it also does not provide expressly for any claim for trespass. As for the Strata Management Tribunal powers, in making an award pursuant to Part 2 of the 4th Schedule of the SMA, the tribunal may order a party to pay a sum of money to the other party, order the price or consideration paid by a party to be refunded to the other party, or order the payment of compensation or damages for any loss or damage suffered by a party. They can also order for the rectification, setting aside, or variation of a contract or the bylaw in whole or in part, order the cost of the proceedings of no more than 5,000 ringgit, or order interest at a rate of no more than 8% per annum. Or alternatively, the tribunal may also dismiss a claim if it considers it to be frivolous or vexatious. So the tribunal can also make any award which is under its jurisdiction made under Part 1 of the schedule and make such consequential orders in order to give effect to any of orders made by the tribunal. So what are the common examples we see within the tribunal's jurisdiction? These are the common claims that our firm has. So one of it is the claim for outstanding maintenance charges. This will likely be from the developer, the JMB or the MB, trying to claim back for outstanding maintenance charges from a parcel owner, a proprietor for default or a defaulter, a claim for maintenance account fund, claim for damages due to building defects. This will likely be from the proprietors and parcel owners, challenging maintenance rates. Let's say if you think that the maintenance rate that were fixed were too high and disproportionate and not according to the SMA, you can challenge that. And a lot of parcel owners we see also challenge the validity of an AGM or an EGM. So who can file a tribunal claim? If you're watching this video, I assume that you will fall under one of these categories under Section 107 of the SMA. So a developer, a purchaser, a proprietor, the JMB, the MC, subsidiary MC, managing agent, and basically any other interested person with leave of the tribunal can file a claim. And moving forward, what are the procedures and proceedings? How do you start claim? Well, if you can see here, these are the main forms which I will go into shortly, and these are the supplementary forms that parties can file. So what is Form 12? Form 12 is a notice of application for summons to appear. This is the summons to call the witnesses that you require, or even to ask people to produce documents on your behalf. And Form 14 is another notice of application where you can apply to the tribunal for interlocutory orders. Interlocutory orders include the discovery application, the interrogatory, as well as the security of cause application. And in Form 16, you can also apply to set aside the tribunal award. And these are the forms that can come from the tribunal, which will be later discussed as well. So where can you obtain this form? First, there is the regulation, which I previously mentioned before. If you flip the regulations all the way to the end, all the forms are there. So there is a BM, a Malay version, as well as an English version. So you can choose which one to fill. And if you go to the Ministry of Housing and Local Government site, the forms are also there. I recommend going to both sources because some of the forms in the regulations are not in the website and vice versa. So be sure to check both before you start your claim. And what is the tribunal's procedures and proceedings? So first, the person who is instituting the claim, commencing the claim, or wants to claim for something will be called the claimant. Very simple. And the person who wants to defend the claim will be called the respondent. I guess if you respond to the claim and therefore they're called the respondent. So the claimant will first file statement of claim at the tribunal. Make sure that you serve it within 14 days, but in any event, the statement of claim is valid for 30 days only. So if you miss out on the 30 days, you will have to refile your statement of claim and you will have to pay the prescribed fees all over again. And then once you serve it on the other party, the respondent will have 14 days to reply to the statement of claim in Form 2. And then if there is a counterclaim, the claimant is again allowed to file the defense for the counterclaim in Form 3 within 14 days again. Thereafter, the tribunal will send a notice of negotiation or a notice of hearing. This is to their discretion. And then thereafter, the parties will either go for negotiation or hearing. And then the tribunal will give its award. Form 11 will be the award after a full hearing. So this is a sample of statement of claim in the Strata Management Tribunal. As you can see, as previously mentioned, it's stated here at location in the state of Sabah, Malaysia. So you have to see the entitlement to see where to serve your defense back. And as you can see, these are all the details that you have to fill in, and you also have to fill in the claim and claim, the particulars of claim, and these are the other details. So the tribunal proceedings are open to the public, and no representation by an advocate or solicitor at the hearing is allowed unless leave of the tribunal sought. So this is where the case involves complex issues of law, and one party will suffer severe financial hardship. And let's say if the claimant is allowed representation, then you as a respondent will also be allowed similar representation. And if you're a company, you may be represented by a full-time paid employee of company. This is the list of prescribed fees. You can also find this in the regulation itself. held, and practical tips for your tribunal hearing day. Please remember to bring your IC, and if you're representing a company or a GmbH, MC, please bring your letter of authorization. Bring along your proof of service forms as well. So depending if you serve by hand, bring the letter with the chop, with the date and the signature, the time, or alternatively, if you have done this through AR registered post, please bring your AR registered postcard and ensure that all your documents, which are the tribunal forms that you have filed and all the evidences that you have are present. And for your information, these evidences can include documentary evidences and also recordings. Yes, you can also bring in recordings, and you can also bring in basically anything to prove your case. So that's all from me today. On to you, John. Thanks.
Hi, everyone. Thank you, Celine. I hope everyone is doing well on the second day of this MCO 3.0. I will be continuing with the topic of award and compliance. Now, the SMA states the tribunal shall make its award without delay and where practicable within 60 days from the first day of the hearing. The SMA also states that the tribunal shall give its reasons, or what we call grounds, for its award in the proceedings. Based on these two cases and number 3, it is also mandatory for the tribunal to give its reasons. Now, the question of whether these reasons or grounds should be in writing, there are two decisions for that, for yes and no. The High Court in Tangkavelu and Lokanath, both cases say that no, it is sufficient for the tribunal to give its reasons verbally, and the High Court in Perbadanan Pengurusan Sunrise Tower said yes, the tribunal must give its written reasons. So these are 3 High Court cases which have decided this way, but as I understand right now, it is standard procedure for the tribunal to give its written reasons after its award. This is Form 11, which is the format that the tribunal award will come in. Here you will see the entitlement, followed by this action having been heard before the President's name on the date at, I believe, the place of the tribunal. The tribunal hereby orders, followed by the orders that the tribunal makes. Now, apart from this standard award, which I showed in Form 11, there are also other types of awards. Yes, there's award by consent, where parties enter into a settlement agreement during the proceedings. There's also award for the claimant, where the respondent fails to file its defense. There's also an award where the respondent admits to the claimant's claim. This is where the respondent files the defense, but in the defense admits to the claim of the claimant. So then the tribunal will give its award under number 3 you see here, Form 8. And if the claimant is absent, then the award for the respondent will be in Form 9. And there's also an award for the claimant where the respondent is not present during the hearing. Okay, so what happens if the respondent fails to file the defense under Form 2, either within time or he fails completely? So the tribunal may make an award for the claimant under Form 7 during the hearing, or the tribunal may also adjourn the hearing to enable the respondent to file its defense. Or the tribunal may also allow the respondent to submit his defense orally and proceed with the hearing. Usually for circumstance C, it is where the respondent has at least written a letter or indicated to the tribunal that yes, he has not filed his defense, but he will be coming to the hearing to argue or submit his defense verbally in the tribunal hearing. And what happens if a party is absent during the hearing? Under Regulation 25, the tribunal may proceed with the hearing. The tribunal may adjourn the hearing to a later date or give an order or make an award as it thinks appropriate. So the award here under Forms 9 and 10 is where one party is absent and the award is given to the present party. So based on these two regulations, we can see that filing of your defense is important, and make sure you file it within time. Not only filing, but serving it on the claimant within time. And secondly, it is also important to be present at the hearing. Now, we would like to share with you this case of Badan Pengurusan Bersama Pangsapuri Seroja, where 181 parcel owners filed a tribunal claim against the MC due to damage caused by interfloor leakage. Now, in this case, the MC did not file the defense and also did not show up at the tribunal hearing. Subsequently, the tribunal made an award in favor of the 100 over owners. After the award was given, the MC applied to set aside the award, but the tribunal dismissed that application to set aside the award. And so after that, the MC filed a judicial review to the High Court to challenge the tribunal's award and also the order of the tribunal which dismissed the setting aside application. Now, the High Court dismissed the judicial review because the MC failed to give reasons for its failure to file the defense and also failed to give reasons for its failure to attend the hearing. Ultimately, the court held that the tribunal's award and the order dismissing the setting aside application was not perverse, illegal, irrational, or unreasonable. So here you can see that whether or not the MC may have had a defense defense on the merits of the interfloor leakage because it did not file the defense and did not show up at the tribunal hearing. And then when it tried to set aside the award, it couldn't give any good reasons for its failures. The tribunal and the court will not entertain such a setting aside application. What happens in a non-compliance of a tribunal award? Firstly, the Act provides that it is a criminal offence, and upon conviction, person in breach would be liable to a fine not exceeding 250,000 or imprisonment not more than 3 years or to both. And for continuing offences, a further fine not exceeding 5,000 ringgit for every day or part thereof. This is based on Section 123 of the SM. Also, still on criminal liability, we can see in July 2020, last year, this is the first ever case. The Subang Jaya Municipal Council, or I believe it's Majlis Bandaraya Subang Jaya, via its COB, prosecuted a parcel owner for the parcel owner's failure to comply with an award, which ordered him to pay outstanding maintenance charges to the management body. Magistrates Court convicted the owner and imposed a fine of 5,500, and if in default, 1 month imprisonment. So not only does he have to abide by the tribunal award to pay outstanding maintenance charges, he now has been convicted and has to pay a fine of 5,500 for failing to comply with that award. But so far, this is the only case that we know of where criminal prosecution has been commenced against a party who has failed to comply with a tribunal award. If you do not comply with the tribunal award, you may also be exposed to civil execution proceedings. Section 120 of the SMA states that a tribunal award is deemed to be an order of court and can be enforced accordingly by any party to the tribunal proceedings. If the award has not been complied with, the Secretary of the Tribunal will send a copy of the award to the court, and the court shall cause the copy of the award to be recorded. So what it means here is that the court will recognize the tribunal award, record it in its documentation or its system as a court order itself. And this procedure is called an Inca award procedure. To commence this Inca award procedure, you can file this Inca award notice to the tribunal, where you will need to fill up your tribunal claim number at the top, address it to the secretary. The title is as such, a notice to inform that either the claimant or the respondent has not complied with the award, Inca award. And so once the tribunal secretary accepts this notice and seals it and signs it, it will send it to the court to be recorded. And once you get back a copy of this signed and sealed notice, you can then enforce it by way of civil execution proceedings. That is a topic for another day, but just briefly, some of the modes are bankruptcy proceedings if it's against an individual, winding up proceedings if it's against a company, committal proceedings, which is for contempt of court. You can file a judgment debtor's summons, or garnishee proceedings. So all this will be in the civil court. Next, I will explain a little bit on how to set aside a tribunal award. To set aside a tribunal award, it is only for cases where the aggrieved party failed to file a defense or failed to appear at the hearing. The application shall be made in Form 16 and shall be filed within 30 days of receipt of the tribunal award which he wants to set aside, and must contain detailed grounds on why the award should be set aside. Basically, this means that the detailed grounds must explain why he did not file a defense or why he did not appear at the hearing. This is provided for under section paragraph 48 of the regulations, and this is the Form 16 template. You can see here at number 3, I was not present at the hearing because, or number 4, I did not file my defense because. Next, how do you appeal or challenge a tribunal award? The answer is by way of judicial review to the High Court, and it is provided under section 121 of the SMA, where a party may, upon notice to the other party and to the tribunal, apply to the High Court challenging an award in the proceedings on the ground of serious irregularity affecting the award. And what is the meaning of serious irregularity? It means an irregularity of one or more of the following kinds which the court considers has caused substantial injustice to the applicant. Failure by the tribunal to comply with section 113, which I will explain later. Failure of the tribunal to deal with all relevant issues, or uncertainty or ambiguity as to the effect of the tribunal's award. So if you are a party filing the judicial review to challenge a tribunal award made not in your favor, you must be prepared to show all this, either all of this or one or more of this from A, B to C. Now, what is section 113? It is equal provision for equal treatment of parties during the tribunal proceedings, where the tribunal must act fairly and impartially as between the parties, so that each party has an opportunity to present his case and dealing with his opponent's case. Now, what if you succeed in showing serious irregularity? The High Court may set send back the award to the tribunal in whole or in part for reconsideration, meaning a rehearing, or set aside the award in whole or in part. Now, questions have also been asked whether the High Court can consider the merits itself and make a decision without remitting the award back to the tribunal for a rehearing. The answer is yes, because the High Court has that jurisdiction and power to do so. Now, coming back to the procedures of the tribunal, this is the website that you can go to, www.kpkt, which is Kementerian Perumahan dan Kerajaan Tempatan, where most of the forms are there, the basic forms are there. There is also a quite useful FAQ where you can read if you have to either start or defend a tribunal claim. And that is all from me. Over back to you, Ashwin.
Thank you, Celine, and thank you, John. We will now take questions from the floor. If you have any questions, please scan this QR code, or in the alternative, you can go to the Slido website and enter the number 793955. First one is from Izwan. The question is, what can we do if the owner still refuses to pay even after judgment has been served? Appreciate if the answer could be in step by step. John, would you like to take this question?
Yes, sure. So what can the owner do? What can we do if the owner still refuses to pay? So as you can see earlier, firstly, a step-by-step answer would be, firstly, I think you should make a police report, bring the award with you, and also maybe the section with you so that you can quote it in the report to say that this owner has failed to comply with this award. So that's the criminal part. And then what you can also do is you file the Inca award notice to the tribunal for your civil rights. So in terms of criminal liability, once you file the report and maybe then you bring that report to the COB, your action ends there because it is a criminal proceeding. Only the AG's chambers, the Attorney General's chambers, and the public prosecutor has the discretion whether or not to start criminal proceedings. So what you can do is you make a police report and then you serve that police report on the COB and then you just follow up. And with the civil rights, yes, what you do is you file the notice Inca award, and then you commence execution proceedings against that defaulting owner.
The second question, how to enforce an award given by the tribunal? How many types of enforcement are there?
Yeah, I believe this was addressed in our slides. The types of enforcement are around 7 to 8, including bankruptcy, winding up, contempt of court proceedings, garnishee proceedings. If you know the defaulter's bank accounts, you can garnish monies from his bank accounts, and including judgment debtor summons, where you call the debtor to come and explain or show proof why he has not been paying according to that award.
Thank you, John. What is the time frame to comply with the award if it is not stated in the award? John, maybe you would like to take this as well.
Yep. SMA does not provide a time frame, but what the tribunal can usually award is to say that a certain payment must be paid within 14 days or 30 days, or you can say that this act must be done within 30 days or 2 months whatsoever. So if the award is silent on the time frame, then there is no time frame. It is up to you to make a demand, file the Inca award, and make the police report.
Thank you, John. Please elaborate further on uncertainty and ambiguity of the award. John, would you like to take this?
Yep. There are not much examples in case law, but what I can think of is, for example, the award says, the claimant wins, and it stops there. So it doesn't say what the claimant must do, what the respondent must do. Yeah. So that is in terms of ambiguity towards the award that I can think of. That is the simple example. A more elaborate example would be further ambiguities. For example, although the claimant has won, the further orders state that the claimant must pay certain amounts to the respondent. So there is some ambiguity. Why would the claimant be ordered to pay certain amounts of money to the respondent when the claimant won or was ordered to have won the case?
Okay, thank you, John. The next question is, who is responsible to ensure the share unit is correctly calculated? Celine, would you like to take this?
This is actually not a topic that we are currently discussing today. John, would you like to discuss this topic, actually?
Yeah, sure, why not? In general, the share units at the beginning of the development of the strata scheme should be correctly calculated by the developer and or its appointed surveyor. And then you have, so that's the general principle or the general law.
Thank you, John. Can we bypass the tribunal proceeding and file directly to the civil courts for any remedy available? Celine, would you like to take this?
Generally, yes, you can file to the civil courts. I mean, especially if your claim is more than 250,000, but we do not really recommend that because the tribunal is a lot faster and you can do it yourself. It is a lot more cost efficient and expedient. And it really depends on the case-by-case basis, I believe. John, do you have another answer for that?
I suppose it would depend on the complexity of your claim or the subject matter. If it's, for example, a claim for maintenance charges, outstanding maintenance charges, then yes, you can go to the tribunal. But if you think it's a bit more complex, a bit more technical, then some parties would prefer going straight to civil courts, which have, I don't know, they feel that the civil court judges are more technically equipped to deal with complicated matters. Especially if the claim is for an amount higher than the tribunal's jurisdiction.
Thank you, John. If the failure to comply include a imprisonment penalty, if it is against the MC, who will be liable to go to the jail?
Regarding this question, I believe if it's against the MC, which is the body corporate, then a jail sentence would not be imposed and only a fine. But to go deeper into this answer, if it can be shown that the individuals are purposely ignoring or making it actively refusing to comply, then yes, maybe a jail penalty can be imposed. But in general, if a MC, which is a body corporate, is charged in court, usually only a fine will be sought by the prosecutor.
Okay, thank you, John. How to measure whether the managing agent is performing its job? For some condominiums, there's no proper minutes of meeting displayed at notice board for a long time. John?
Right. Yes. This question is a bit general, but how you measure whether an agent is performing his job is to always go back to the SMA and the SMA regulations, and there you can assess whether the agent is doing this or doing that or not. If not, then you have the right to either raise it at a general meeting, or you can always write for an explanation. If all this is being ignored, then your rights to the tribunal is open, where you can file a claim to seek for answers or to compel the agent to perform its job pursuant to the SMA.
What if the particular unit's owner left the unit empty and hasn't paid maintenance charges fees for a long time? How to file a claim if the owner is not reachable? Celine, would you like to take this question?
Yeah, sure. Thanks, Ash. Well, basically, what we usually do is you can also conduct an IC search to get the address of the owner. Or, if there is any unknown addresses to you, you can serve the tribunal claim there or try those addresses. Alternatively, you can file the tribunal claim. And also, if the owner really doesn't show up and you've exhausted all the addresses, then, you can enter one of the judgment where the respondent doesn't appear, and you can also execute execution proceedings in the civil court later to enforce the award if the unit owner remains uncontactable.
John, would you like
and I believe the regulations also provide for circumstances, or it regulates that the service is complete once you send it out by AR registered post, or you leave it at the last known address of the respondent. So then that is considered as the Form 1.
Can a developer file a case at tribunal before JMB is formed? Celine, would you like to take this?
Well, a tribunal case can be against the developer as well. So it's if it's a case where it's still in the developer's managing period, because I'm not sure what in particular are you claiming for. So if it's something to do with the defects of the building, that kind of matter, yes, I think that you can file it against the developer. They are the managing during those times, as well as if it's a claim for maintenance charges. I think that you can file against the developer at the material time.
Yeah, I'm writing for it.
What if the owner is a foreigner, would incur award, and is not residing in Malaysia, but the correspondence address registered in Malaysia? Let me rephrase this. What if the owner is a foreigner who incur award and is not residing in Malaysia, but the correspondent address registered in Malaysia?
I think let's address the outside of Malaysia issue as best as you can gauge this question. Once you get the incur award sealed by the tribunal and recorded by the magistrate's court, what you do is you start your execution proceedings. Then the question comes, how do you serve that execution proceeding summons or notice on the person who is not in Malaysia? The rules of court, and this is the civil proceedings, the rules of court provides for several modes on how you can serve originating process or the notice or the summons of the execution proceedings on the person who is outside of the jurisdiction. So this includes appointing a solicitor in that jurisdiction, in that country, to try to serve your document on that person. If you really do not know where he is outside of the jurisdiction, then unfortunately you can't do much. Too bad.
Which authority do we go to before tribunal to resolve the disputed interest charges due to the fault of MC? John, would you like to take this?
Which authority? I believe if you feel that the interest charges are illegal or improper because of the MC's default, you really either try to get it reversed at a general meeting, or you go straight to the tribunal or court. There is no other authority before the tribunal or the court. We have seen some cases where the owners or the affected owners write directly to the COB, but usually the COB doesn't do much, and we as lawyers take the position that the COB's decision is only an opinion and it's not binding. We usually advise them to go straight to tribunal or the court to resolve the matter.
Yes, the slides will be given to everyone at the end of this talk. Is the appointed managing agent accountable together with the JMB or MC? Celine, would you like to take this?
Right, yes. Yep, sure. So from the cases that I have been involved in and from the cases that I've seen, usually if there was an appointed managing agent at the time, usually we do sue the managing agent. We do bring them in as a defendant or a respondent together with the JMB or the MC that appointed that managing agent at a particular time. But because of the fact that the JMB and the MC or the MC are the ones who appoint this managing agent, you have to bring them along together as well. John, do you have further thoughts on this?
No, I think the general principle would apply, which is if you engage an agent, whatever the agent does, you will be accountable for the agent's conduct, even outside of strata management.
From your experience, how many cases regarding the payment of maintenance charges problem is brought to the tribunal court? And what is the effectiveness or result of the cases? John, would you like to take this?
I think there is a significant amount of cases for outstanding maintenance charges in the tribunal, and probably a majority of them is regarding maintenance charges.
The MC was prepared in favor of developer. How to have the indemnity and force merger have the purchaser interest being cared for?
DMC would refer to deed of mutual covenant, was prepared in favor of developer. How to have the indemnity and force majeure have the purchaser interest being cared for? I think if it's in relation to your SPA and your DMC, and you think that certain clauses is not in the purchaser's interest, I mean this question is quite ambiguous. We would advise you seek legal advice specifically on what terms you are concerned, because the SPA and DMC has already been signed and would be binding on you already. So yes, please do seek specific legal advice on this.
Which department and where can I do this search by using owner IC number? Celine, would you like to take this?
Yeah, sure. Actually, you can just look at the Jabatan Pendaftaran Negara portal. The procedure is all there, but if I'm not mistaken, you do have to get a law firm to do it for you, because law firm will have to do the formal letter and all. Or another governmental agency or like an enforcement agency can also do this. So you do have to make a formal application with the letter of authority to do the address search, which is called a Cabutan Daftar Alamat.
We will be taking last few questions. Will any members of the MC be liable in his or her personal capacity? John, would you like to take this?
Yes, the answer to this again would be twofold. One would be criminal liability, which is under the SMA, and civil liability, where we have seen cases where either owners or the new MC members have sued old MC members for their breach or negligence in managing the strata property. But usually it is not so easy to succeed, because it's not so easy to prove an MC member's failure or negligence unless it is clear-cut criminal breach of trust or fraud, anything of that serious nature.
I think we will take one last question. I'm sorry we couldn't address all the questions in today's talk. If you would like to have a complimentary legal consultation, we will share with you the slide at the end of the talk later. The last question is, back to the question about owners who are not reachable. How can the tribunal assist JMB to claim the maintenance charges given that the owner is not aware? John, would you like to take this?
Yep. So the tribunal is not there to assist the JMB, but the tribunal is there to make sure that if the JMB is claiming for maintenance charges, the tribunal is there to make sure that the claim is genuine, can be proven, and follows the SMA procedures. So for example, before the JMB can go to the tribunal to start a claim, it must comply with Form 20, I believe, which is a notice to the defaulter to demand for basically it's a demand notice to demand for the outstanding maintenance charges. And only only once that Form 20 is not complied with can the JMB file the tribunal claim or the claim in court. So yeah, coming back to the tribunal would be duty bound to ensure that all these have been complied with and make sure that the JMB's claim is genuine and can be proven even without respondent being present, because the respondent is not aware, right? Yeah, so that is what the tribunal is there for. But coming back to, again, general principles in terms of litigation, even in civil courts, if a claim is filed, defendant is not reachable, the plaintiff can always file substitution of service, meaning to say that it has done all it can to notify the defendant and therefore get a judgment in default.
Thank you, John. We will now conclude the Q&A session. Thank you, John and Celine, for your insight. Everybody, y'all can access to our Strata Management articles on our website. These are some which have been posted on our website. Before we conclude, I have a few announcements to make. First, please join us again for our upcoming talks. The next one will be held on the 16th of June, where our associates Diana and Anis will be speaking on Introduction to Mediation. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link of the form will be posted in the chat. Thirdly, please follow or like our social media accounts. Fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link will be posted on our chat box. To our guests, thank you for joining us. We hope you have found today's session informative and useful. We will see you at our next talk.
Thank you everyone. Good session. Thank you. Bye-bye.
Thank you, Dato'. Thank you, everyone.
Thank you.
Take care.